Okay, thank you for all for coming out. This is the regular meeting of the committee to save Jefferson County. And we thank you for coming out. And we think this is a very important meeting because it's talking about the future of Jefferson County. It's talking about how the lines are being drawn. So we're glad you're here. You're interested in getting information because it's going to affect everybody's life. Now, my name is William Muhammad, for any of you who don't know, one of the co-chairs of the Committee to Save Jefferson County. And I just want to say before we begin that we've been involved in everything that has happened in this area over the last almost 30 years. So this is kind of like a culmination of it. I've always said that once we got this done, that I could retire. I could go home, but it don't need a lot of approval from the people that I say it to. So I guess you had to die out of this stuff, but we thank you for coming out. And like I said, this is really big. This is big to be in this situation. I am one of the plaintiffs on the case. And one thing I heard while we were having our meet and greet, I heard the lawyers that are here, Attorney Rice and Attorney Roku, discussing the differences in the maps. And I really didn't know that there was a difference that's being presented by the two different groups that make up our side. And so that's interesting because I'm going to learn something today, because they talked about the map that our attorneys, these are our attorneys, Mr. Blackshear, who have been known for years, and he's been working on this a long time, maybe for the last 70 years. I don't know, Jim, whether it's been that long, but we had to realize that the two different groups, that's the point I'm trying to make, are proposing, even though we are on combined case, they're proposing two different maps, and we need to think about that today. The map that they talked about that being proposed from our side of the case is a map that keeps, is it like the county whole or the city's whole? It does not split boxes, it sounds like, to where even though our other friends that are on the case, they are proposing that the NAACP, Legal Defense Fund, is proposing something different. So that's why this is important. We're glad to have you here. We're not going to hold you up because it is Saturday. And Saturday doing football season. So thank you all for coming out. Give yourself a round of applause. Thank you, thank you. We're glad to have our media person with us, Jarvis Escott, because we stumbled upon something during the last elections that whenever we put this stuff on Facebook, you know, I'm 73 years old, and I said this would probably give me the opportunity to retire. But I'm so far behind in this information, because if we got 100 people to come out to something, man, we felt like, wow, this place would be packed to the brim. But every time we have something and Jarvis screams it, we get thousands of people who look at it. So we really found a new way to get this information out. So thank you all. We're going to get started now.
All right, well, good morning, everybody. My name is Richard Rice. I'm one of the attorneys representing the Adecondi plaintiffs. Richard?
Yeah, my name is Richard Rocco. I'm also one of the attorneys that are representing, we call them the Adecondi plaintiffs, but they're actually many plaintiffs, many voters, I like to think of them, not really plaintiffs. They just happen to be plaintiffs in this case because they brought the lawsuit. But we have, should I list them? I think these individuals deserve credit. They're voters who stood up and decided to help us in challenging what we believe were unfair maps that the county commission had adopted back in 2021 as part of the redistricting process that followed the 2020 census. Jim Blackshear, who's on the screen there, Jim has been doing this, I think, almost about as long as I've been alive. So he is the one that has a depth of knowledge that I think very few people have in this area in terms of voting rights and in particular redistricting. So Jim's going to give a presentation about the maps or the one map that we propose as a group of plaintiffs. But before we get to that, I really do want to give a shout out to Alexis Adelcondi, and the reason her name is first is because it's alphabetical, the way we listed them on the complaint. But there's also Julia Juarez was one of the voters, Cynthia Bonner, Janelle Brown, who goes by Nell Brown, and I think Nell's here, and Nell can speak for herself, but I think maybe this case motivated her to run for office. So she's thrown her hat into the House District 15 state race that's coming up in 2026. Charles Long, Eric Hall, Michael Hansen, William Muhammad, Dr. Muhammad, Tammy Smith, Fred Lee Randall, and Robert Walker. Those are the voters who helped us bring this case, and all of them participated in the litigation. They had their depositions taken, so they had to take time out of their schedule to help us push this case forward. The litigation team that brought this case on behalf of these 11 voters were Richard Rice, myself, Jim Blacksher, and Judge Clement, who was going to be with us today, but I think he wasn't feeling well, so he sort of had to skip coming in this morning. So I'll give you a little bit of background, then turn it over to Jim about the case. This case actually starts in 1985 with the consent decree. Back in 1985, there was a consent decree that was entered that created two minority districts in Jefferson County, because there had never been any minorities elected to office of the county commission. At the time, prior to 1985, the county commissions were elected at large, and there were 3 county commissioners. In 1985, there was a consent decree to change that. This case evolved from that because when the creation of those districts were necessary back in 1985, there's never been a recognition that the county has changed, a lot in the last 40 years. And but the county commission continued to keep the districts as they were, and we believe that was for an intentional reason. And that was to minimize the power of minority voters in the county by keeping them in the same districts and at very high elevated levels of voters in 2 specific districts. So we thought that it was time for the county to take a serious look at the county and to draw maps that were fair maps that gave all voters an equal opportunity to choose representatives of their choice, or to elect representatives of their choice. That's what motivated the litigation, because it was kind of like we had maps that were frozen in time and did not evolve with how the county evolved. And that sort of led us to bring this case. And our report, we were successful. We were able to convince a district court judge. Her name is Judge Madeline Heikela. We had a week-long hearing in front of Judge Heikela where we presented, there were like at least 5 expert witnesses that testified, and something to the tune of about another 10 or 15 live witnesses that gave testimony about the importance of this case to them as voters, and then the things that they would like to see the county do, but that seemed to be impeded because of the political structure that we were frozen into. So we brought that case, and she agreed with us, and now we're at the stage of proposing remedial maps. Because the county, typically in this type of litigation, the governing body gets the first chance of redrawing the map to make sure that it's consistent with what the judge has found. So in this case, the judge found that the maps, the districts that were drawn as part of the 2021 redistricting cycle were a racial gerrymander, and that they violated the 14th Amendment of the United States Constitution, which prohibits racial gerrymanders. So the judge, upon making that finding, then goes back to the parties and says, we need, now you need to propose to me a map that remedies, that fixes the violation that she found. Typically, that is something that's left to the county commission or whatever governing body. It can be the state, right, a city. Usually when the judge has found that a voting map of the voting districts violate the law, the governing body is given the first opportunity to redraw the districts. In this case, Jefferson County passed on that. They decided, well, I shouldn't say that. It appears that they have. They did not propose a map to the judge that would fix it, so we then proposed our remedial map. It's a map that the plaintiffs drew, the Abercrombie plaintiffs proposed, using the expertise of Tony Fairfax, who is an expert in this area and has done numerous redistricting cases for voters. Normally, he's sort of a voting side. He represents voters and has been on the side of voters in their efforts to get certain district maps thrown out and then help redraw fairer maps. So we've proposed a remedial map. You may have heard about the other map that's been proposed by another group of plaintiffs. They're called the McClure plaintiffs, and they are represented by the NAACP Legal Defense Fund. We've worked very closely with them because on the theory of liability, we take the same approach, right? Where we've parted a little bit, and I don't really think it's much of a difference, to be honest with you, but where we have a little bit of difference is the approach on what the remedial map should look like. Our view has been, and Jim will explain this in detail, it takes a slightly different approach to coming up, I think, with the same outcome, which is the court hopefully adopting a map that's fairer than the map that exists today. So I think I've talked too much, but I'll turn it over to Jim, and maybe Jim can walk you through what the Abercrombie plaintiffs are proposing as a map. Jim, I'm going to distribute some of these maps so folks can see what it is that we're proposing, and then they can follow you along.
You can share your screen too, Jim.
You can share your screen too, Jim.
Thanks, Richard. Thanks, Mohammed, and everybody that's there. I can't see, but I appreciate you letting me participate by video. It makes it a lot easier for me to sit at my computer and share pictures of the maps and statistics and that sort of thing. And I think Richard Rocco just gave you a good background on what brought us to this point in the litigation. Let me emphasize two things. First, as he said, Judge Heikla is going forward with the proceedings to determine what kind of remedial map she will award as a court-ordered plan to be used in the upcoming 2026 primary and general election. And we have already submitted our proposal. A proposed plan has happened with four plaintiffs. The county commission must file any objections to our proposals by Tuesday. And then, Richard, we have until Wednesday to reply to their objections. Okay, that was a typo. And finally, if there is a hearing, if Judge Highfield wants a hearing, it will be on the 20th. But while all the remedial proceedings are going on before Judge Highfield, the county commission can appeal.
The county commission appealed.
What did I say?
No, you broke off a little bit there.
Yeah, the county commission has appealed into the 11th Circuit Court of Appeals and asked the Court of Appeals to issue a stay of all proceedings until the appeal is resolved. And if the Court of Appeals grants the requested stay, it would almost guarantee that there would be no map in place in time for the 2026 election. Categorically, that would happen. When the appeal will take months and months and months to go through full briefing and oral argument and a decision by the Court of Appeals. So what happens in the Court of Appeals with respect to the response to the County Commission's request for a stay is crucial. And we very much have our eye on the Court of Appeals to see what happens there. But let's get back to the plan that we proposed. Let me explain the approach we took. Let me, first of all, share my screen for a minute. Can everybody see the screen all right? This is a page 1 of our submission to the Court of Appeals explaining why we submitted this plan. And it explains that as we read the law, the court order plan may not disturb the policy choices the County Commission has made in its map drawing, except to the extent necessary to remedy the constitutional violation. And let me make sure you understand the difference between the constitutional violation in our case and a vote dilution case. Even though, as Richard said, we're all disturbed about the way that keeping intact previous plans kept blacks pinned up in 2 supermajority districts. The constitutional claim we brought of the 14th Amendment is one that the Supreme Court has created. And it does not challenge vote dilution. It challenges the segregation of voters by race, separating voters by race between districts, just based on race. And so, regardless of whether it produces the vote dilution or not. So, we pointed out to the district court had ruled in the decision that's now on appeal that to follow the movement of black citizens from the city of Birmingham and place those citizens in districts 1 and 2, over the years, the commission departed from traditional redistricting criteria. It increased the number of census place goods. Census places are municipalities. Split municipalities, splitting 25 census places in 2013 and 25 in 2021.
Jim, can I stop there to emphasize this point, right? It's a very important finding that the court found. As the African American population of the county moves out to different areas of the county, what the judge found is that the county commission followed them along with District 1 and District 2 to keep the black population in those counties, in those districts. You let that sink in, right? That's what the county commission was found to have done. So as African American communities moved, voters moved out to suburbs, moved out to other areas, they tried to track that movement to keep those voters in District 1 and District 2. Go ahead, I'm sorry. Jim, I didn't mean, I just thought that that's a very significant finding.
So the remedy, since the racial gerrymandering, the segregation of above, carried out primarily by splitting the boundaries of municipal boundaries. That means putting, for example, as it says here, municipalities like Bright, Goldendale, Homewood, Hoover, Midfield, and so forth, putting those municipalities in 2 commission districts, and thus diluting the strength of their elected representatives before the county commission. We told our map lord, Tony Franklin, to start with the plan, the last lawful plan that was adopted by the county commission was in 2013. The Department of Justice declared under Section 5 of the Voting Rights Act the 2013 plan. And of course, only a few months later, the Supreme Court did away with Section 5. So the county commission today can no longer rely on the Section 5 of the Voting Rights Act to justify continuing the way they attack the district's limits. So we asked Tony to start with the 2013 plan and try to restore the boundaries of all the municipalities that had been split apart in order to segregate voting. And that's what he did. And here is the map. I'm going to throw it up in there. I think I'm in it.
Yeah. You got a copy of
The map, that is the Edo County plaintiff's proposal to Judge Heichler for a court ordered claim. And as you can see, even though Tony was inclined to do this, manages to keep each of the incumbents in his or her current district. Here's Stevens down here in Bessemer, in Tyson in West End. Here's Bowling in, I guess, Vestavia Hills. Here's Scales over there on Edwards Lake Road. Here's Murray over here in Trustee. And here are the statistics. This plan splits only restores hold the boundaries of every municipality in Jefferson County except for Birmingham, Vestavia Hills, and Mississippi Hill. Well, I'll get them in just a minute. There are 5 municipalities that are split, and that's all. And here are the numbers. Now this 18 plus, what that means voting age, okay? So the voting age population in these districts are here. District 1 becomes 60.99%. District 2, 63.67% black voting age. District 3, 48% black voting age. District 4, 20% black voting age. District 5, 13% voting age. And let me just show you here. Tony breaks down pictures of each district and shows you which municipalities go in each district. So here's District 1, and here's the picture, and his maps are using this color scheme to help you see where the boundaries of the various municipalities fall. Here he lists the cities that are in District 1. 44.9% of the city of Birmingham is in District 1. 100% of South Point is in District 1. 91.15% of Irondale, which had to be split in order to reach plus or minus 1%, is in District 1. 100% of Karen is in District 1. Just a fraction for Pinson goes into District 1. And that, again, is just a balanced population so that there's less than 1% deviation in one districts. There are some zero population slivers created by the way the county calls their precincts on Vestavia Hills and Mountain Brook. So really, the only districts that are really split, the only municipalities that are really involved are split are Benson, Irondale, and Birmingham in Memphis. Then if you go down to District 2, stop me if anybody wants me to pause. Here's District 2. This is Sheba Tyson. You can see it's mostly Birmingham. Here's some Homewood, Fairfield, Midfield, and so on. You can go down to the table that Cook County did. You can see that 46% of Birmingham is in District 2. All of Homewood is in District 2. All of Fairfield in District 2. All of Midfield in District 2. And then there are these slivers of population that just don't really count because they were just created by the way that the county commission do their policing. Okay, so that's District 2. Let me move down to District 3. There it is. That's the western end, of course, of the Jefferson County. It's got all the Bessemer, as you can see, Uniontown, Pleasantburg. Lots of municipalities in District 3, and they show up in this table. You can see all the municipalities that are 100% located inside of District 3, including Bessemer, which is the biggest one for us. And there's still a sliver of Birmingham. Again, that's the, Birmingham is so spread out because of the way the city was annexed over the decades. But you can't avoid splitting some part of Birmingham. And there's a splitter of Hoover. Again, that was had to be included. Less than 1% of Hoover is in District 4. I'm sorry, District 3. Again, because of population equality problems. Gardendale has a splinter that's just not really, is unpopulated. So that's where so many of the whole municipalities are located in District 3. District 4, Eastern Jefferson County, starting with Trussville, Leeds, Benson, Gardendale, and so on. Here's a table that shows all of Trussville, Gardendale, Clay, Leeds, Fultondale, Grayson Valley, Mount Olive, Kimberly, Warrior, Morris, Trafford County. Now there's one I didn't know about. I wasn't familiar with it. And County Liontown. See, you've got to understand that in order to draw these districts for present day purposes, Tony had to use the municipality boundaries that had been created for the census in 2025, not the ones that were used in 2020. So there are actually some new census places, County Liontown and Trafford, I have not seen before. But then you have Irondale is split, has 7% in District 4. Birmingham, of course, has a little bit heavy district. Vestavia Hills has 14% in District 4. So again, we're looking at only 5 municipalities that truly are split between commission districts. So finally, here's District 5, which is the Over Mountain districts. Mountain Brook, Vestavia Hills, through almost all of Hoover is there, almost all of Vestavia Hills, totally all of Mountain Brook. And then the fragment of Birmingham, a fragment of Irondale. And that's pretty much your five split municipalities over there: Blue, Vestavia Hills, Mountain Brook, Birmingham, and Pineview. So that's the Adams County Planners proposed plan. Are there any questions before I show you the plan that includes?
Just curiosity, I know I'm the video guy, but I'm just looking at, which district do you all predict would produce the majority African-American candidate?
The third after the
If you look at, if you look at the population summary,
Okay.
right? The goal is, so you understand, these population summaries, right? If you look at, it has, for District 1, it has the percentage, you see AP, BLK, that means any part black, right? And that's data that's drawn from the census, because that's one of the options people have when they mark the census. You can say single only white, single only black, any part black. That represents, so District 1 on this map is 64%, 64.6% any part black. It's basically the same for District 2. District 3 is 49.79% any part black, based on this map. And the important point to make is that these demographics fall out of following one simple principle, two principles. One is to try to adhere to the map as it existed back in 2013, as closely as you can. And second, to minimize the number of municipal splits. When you follow that principle, this is the map you get. And these are the demographics you get, which simply supports the position we've been taking, that the map that was adopted in 2021 intentionally split many more municipalities than it was needed to in order to try to put, as the judge found, follow black voters as they moved into different areas outside of the city of Birmingham. If you just simply say, we're going to take an approach, we're not going to really we're not looking at race, frankly. We're just going to draw a map that tries to minimize the number of municipal splits. This is what you get. So you have to work pretty hard to avoid this. In other words, you have to start splitting a lot of municipalities in order to get a different map that, actually, in order to get the map that you have today, which is the 2021 enacted map. So to answer your question, the demographics are what they are, and you end up, we didn't set out to draw a third majority minority district. That could have been done, I believe, if we wanted to, but that was not what we set out to do. Or Tony Fairfax, actually. He set out, he was just given instructions, look at the populations, look at the map, as Jim said, look at the map as it existed in 2013, and follow this principle. Try to minimize as many municipal splits as you can. Birmingham has to be split just for the sheer fact that it's got more people in it than each district can have.
And
right?
Right,
it's the largest one geographically. Annexation, as Jim was saying, Birmingham's really kind of split up itself because it's annexed a lot of different areas. But you could not put Birmingham into one district because it has more than 134,000 people living in the district. And that's the ideal. The target is, if you look at the demographics, you see where it says ideal district populations, right under the table, it says total population is 674,000, right? Right below it, it's the ideal district populations is 134,000. You see that number? The reason you have that number is because the Constitution requires one person, one vote. At least it tries to get you as close as possible. In other words, you can't have a district with 500,000 people in it, and then another district with only 1,000 people, and they each get the vote. They each get one commissioner, right? That's the basic idea behind it. So when you take the entire population of the county, you divide it by 5 districts, that gives you the ideal population. Now, the law recognizes you can't always reach the ideal because of how populations are spread out in the county, but you have to try to reach, I think the goal that we set, which is the same goal that the county set, is plus or minus 1% variation from ideal. So you'll see the way this map is drawn, all the districts are within 1% either higher or 1% less than the ideal population district. So if you take ideal population district, you start with the 2013 map, and you try to minimize the number of municipal splits. This is what Tony Fairfax gets. Sorry. So that's how we approach it. And we think that's completely defensible, right? Because the attack that we get is, oh, you're just focusing on race, you're focusing on race, you're focusing on race. And you know, obviously race played the role in it because that's what the county was doing, right? You can't ignore it, but that's not what our map drawer did. Our map drawer started with, let's just look, and neutral factor, big neutral factor that the courts look at is keep political subdivisions together to the extent that you can. And that's what our map drawer did. And when he did that, this is what you get.
I got a question, which is kind of off the subject a little bit, but it just came to my mind. You said one man, one vote. Has there ever been anybody filed a lawsuit because the way we vote is set up in such a way that it discourages people from voting? That 7-7 one day thing. Anybody ever filed a lawsuit?
You know, I don't know if anyone's filed a lawsuit. That you know, you can pick out a lot of different things. For example, why does Alabama only have basically 1 day voting, right? It doesn't have any early voting. You know, you can't. Some people say absentee ballot is kind of a form of early voting, but it's not. You know, you have to jump through a lot of hoops to vote absentee, right? Why not? Why can't you just have the polls open like some jurisdictions do for 2 weeks before the election? So you just show up and vote, right? You just have poll workers, and it's much more convenient. Why don't we vote on Sundays, right? Well, there's a reason why, or Saturdays. So there's a reason why we don't vote on weekends, right? Because working people work, most of them. Not that working people don't work on weekends, but working people, most of the vast majority of them work. There's been no challenge. I'm not sure that such a challenge would work, unfortunately, but I'll let Jim answer that question. Jim, are you still there?
I'm still here. What's the question?
The question is, is it viable for Alabama to file a lawsuit over the fact that its voting, you know, the opportunities that it gives for voters to vote are so limited in comparison to what other states do?
No, that's because of our 1901 Constitution. Our Constitution, which was established to maintain white supremacy in this state forever.
Yeah.
Next.
Next question.
I'm a shade tree lawyer. That's the basis
No,
of it right there.
the thought has crossed my mind too. Why can't we in Alabama have more than just 1 day of on-site voting? You know, people coming to vote without having to go absentee, right? You can do it still. I mean, you can vote absentee, but you got to go to the courthouse, bring all your ID, fill out your affidavit, and you know, and then give a reason why you're not there on the day. Well, some people have to fudge that a little bit, you know.
No,
but
it says, I think I'm not going to be home that day, so you can't question thought.
yeah, so that's always the response is that, well, we really do have early voting. It's just you know, we don't call it that. I'm sorry. So I think Jim was going to present the other map and talk a little bit about the map that the legal defense fund.
Right.
Who, you know, they're great lawyers there. Have the ultimate respect for the lawyers that work for the LDF. But we had just a slightly different approach because I think I think we both have the same objective, It's just, we think our plan is more defensive. Because you gotta face the reality of what kind of bench you're facing, right? What are the judges that you're gonna, how they're gonna look at, and the way the law's been evolving with the Supreme Court that we have. You gotta deal with that reality. And we thought that this map accomplishes the goal, which is giving more fair representation. But it runs less of a risk of getting reversed. So, hey, Jim, you want to talk about the LDF plan?
Send them a picture of it.
That's
And you see. Numbers up here. Here's the picture. Here are the numbers. It splits 16 municipalities. Let's see. And here are the numbers, voting age, population.
yeah.
Right there.
So if you look at their district, can y'all see those numbers?
No. I
Okay.
can see them.
The District 1, any part black is 76%. District 2, any part black is 64%. District 3, any part black is 25%, 25.8%. And then District 4 is 25%, any part black. And District 5 is basically 14%, any part black. Yeah, I mean, that was their approach. That their expert used, McCartney. They tackled it the same way. We just we both agree that District 1 and District 2, that those districts right now, as they're currently configured, are not constitutional districts. Right? We both agree that they violate the Constitution. Their expert came at it one angle. And this is the map that they think remedies the violation. Our expert took a different approach, a broader approach, which sought to minimize municipal splits, and we end up with our map. It's just two different approaches.
Just thinking out of the box for a minute, you think there's a chance that the court will adopt your plan or draw its own plan?
Well, yeah, that's a good question,
Yeah.
Congressman. I think that given we're in a big rush, right,
Yeah.
to do this, because the county has taken the position that you have to have a map in place a year before the election. Now, more than a year before the election, right? They're taking the position that the map has to be in place for, the election is November of 2026. Basically, yes, a year in advance of the election. And that's because they claim that you have a 1-year residency requirement. I've always found that that's an odd reason, to have, I'm sure a lot of incumbents wouldn't mind, that is not going to apply to the incumbents because they're in the districts, right? So it's hard to say why that is an ironclad rule. The law's pretty clear that the court can move that.
Yes.
Right? But they've pushed this, so Judge Heitler has accepted their accelerated schedule. And now they propose a deadline and then they say, oh, but no one can meet that deadline, so we can't do this now. You got to push it off to 2030, right? It's been basically the argument. And we've said, no, we can actually meet it. And that's why we propose these. Whether she's going to adopt...
Recording stopped.
I think given if she's going to agree with them that a map needs to be in place a year before, then she's going to probably take one of these two maps.
Right.
If she feels, and Jim can correct me on this, if she feels that she can modify that, she may look at these maps and then decide that she needs to hire a special master to go and draw.
Now, given the makeup of the appellate courts now, wouldn't you speculate that your plan would be the one most acceptable?
Well, I'll let Jim speak to that, but yeah, I think it is because we start from, the perspective of, let's see what happens if you decide not to minimize the number of municipal splits.
Mhm.
Let's not think about what the racial demographics are going to be of each of the districts. Let's just say we start sort of with the existing 2013 plan, and we start there because that was when y'all have heard a case called Shelby v. Holder, right?
Yes.
That was the year that the Supreme Court essentially gutted Section 5. So after the 2013, so we start with the 2013 map, which was the last map that was in place at the time that Section 5 was effective. So when you remove Section 5 from the picture, then our view was the county needs to try to take an approach of redistricting that tries to just look at a criteria that the courts have found is a valid criteria, and that one was to minimize municipal splits. Apply that to the map as it existed in 2013, and what do you get? And this is what you get. So I think that's defensible, because we're going to say, our expert, and he testified, Tony Fairfax, some of you may know him or not, but he testified that that's what he did. He started from where the county commission would have had to start in 2020 with the new cycle, with the map as it existed, which was the 2013 map, and then applied this principle, and this is without looking at the racial demographics.
And one other thing, in defense of this plan, I live in 3. I moved from 2. And I'm gonna tell you that 49% is more like 50 plus, maybe even 51 now.
Yeah.
Yeah.
No, and that's and that's
District 3.
right, exactly, and that's why it really shocked me when I saw this approach, and
Yeah.
Tony Fairfax produced this
I
map.
like it.
I'm going, really? This is what you get if you just try to minimize municipal splits? I was like, really, truly,
Yeah.
I was surprised that would be the outcome.
And I wanted to ask you to do one other thing before we go back to Jim for me. Could you tell me that the districts, so I can compare them side by side, the 2 different plans? Because that's something that we really gotta talk about, whether we talk about it today or somewhere else, because they combine the 2 cases, but they're asking for 2 different things. And it's kind of, I just had to say this, it's kind of like the legal defense side of the McClure side, they kind of like taking priority over this, like this is the McClure case, when it's definitely different as far as it relates to our people, based on what I learned today, and I'm a plain.
Well,
I guess plain is not the right word.
yeah, you're voting plain.
Because I'm learning today is not the same thing.
Well, the thing, you're correct that when it comes to remedy, we have 2 different views of remedy, or our experts do, okay, about what would be a defensible map. See, but when it comes to the question of whether the map that was drawn in 2021 and voted on, right, back by the county commission, we're on the same side. They think that map's unlawful too.
Have we seen that map? 'Cause I'm
Well,
gonna-
Yeah,
Jim, can you go back,
Okay.
Jim, can you go back to the population summary for the McClare?
Right,
The
but
McClure plaintiffs?
what I was asking was, I was just gonna write it down,
This
because
is
I
it.
missed it when he did something.
Yeah.
So their map is calling for what percentage of blacks in 1, 2, 3, 4, 5, and ours is calling for what percentage, so I could just do a plain old everyday elementary school comparison.
Okay, so the McClure plaintiffs are calling for 76% any part black in District 1
Okay.
and 64% in District 2, 25 in District 3, 25% in District 4, and 14% in District 5.
Okay, now, can you give us ours real quick so I can side by side?
So for the Atacandi plaintiffs, District 1 is 64% any part black. District 2, 64%. District 3, 49. District 4, 21. District 5, 13.
Well, 13.
Yeah, the reality is that, the, you know, I really don't know how to explain that difference, to be honest with you. Maybe Jim understands it. But I think their thinking is that these, that their map also will give an opportunity for voters to elect more candidates of their choice. I mean, I really don't want this to be a situation where we're, you know, arguing against them. I really don't. I don't want to get into that kind of thing. I have a lot of respect for the lawyers at LDF. I think they've done a fabulous job litigating this case. They put a lot of evidence on. They're largely also a very important reason why we got a liability finding in this case, because they did a heck of a job in litigating this case. I don't know the remedy issue, right? I don't know why. I don't understand all the reasons why their expert, McCartney, felt that this was the most defensible plan, but that's the plan that they felt most comfortable with, and it's like it's a small disagreement among friends.
But Attorney
Right.
Roku, well, I'm looking at the numbers, you know, I just said it, they said, numbers don't lie, the figures don't lie, but lies sure can't figure.
Yeah, and that's what I'm saying.
49% black and number 3.
I understand, and I'm just, what I'm trying to say is I have not analyzed, and to be honest with you, I got a lot of things on my plate, so I haven't sat there, and I was concerned with our plan. I analyzed our plan. I thought Tony did a really good job, Tony Fairfax did a really good job on this. So I focused on our plan. I really did not, their plan is what they proposed, and that's fine. All I want to say is that we would not be where we are today without them. Okay, I just want to make that clear.
Oh, yeah, no question.
You know, the LDF did a fabulous, those lawyers did a fabulous job, and they're experts. When we got to trial, they were knocking it out of the park. And we would not, we would not be here today without them.
I need to interrupt you a second, Richard. I've made a mistake. Look up at the screen now. This is the numbers that I showed you for the McClure plan.
Okay, this is different.
Yesterday or day before yesterday. These are the correct numbers.
See?
They have 3
Okay, so it's now it's
black district most definitely.
Because you put 35, 40, and 13.
Yeah, okay, well, that's a huge difference.
Right, it is.
Yeah, so you see, that's not, hey, Judge, how are you? Those are the correct numbers, right? So Jim, I thought so. I was gonna ask you whether you were looking at the corrected table. But if you look at that table, you see that table, they move their expert moves the population around a little differently. They make District 4 more competitive, right? Where ours,
So what the numbers reflect now in terms of majority black
right,
in each district?
their corrected map, which I was wondering if what you had earlier displayed was the correct one, and it wasn't. This is the corrected table that they put in.
And
As
read the
district one.
percentage per district.
Right, on District 1, in the proposed remedial map that the NAACP LBF's expert has put forward, District 1 is 62.76% any part black. District 2 is 57.68% any part black. District 3 is 35%. District 4 is 40%. And District 5 is 13%.
Yeah.
So where the difference really is how the populations work between District 3 and District 4.
Take back everything I said, they're good now.
Yeah, you can take back you can take, their map's a solid map too. They just,
35 before.
right, exactly. So I think, you know, you see, I was right. LDF is, they did the.
Their plan to them was credit already, rather
Yeah,
than rate.
because when I was looking at the numbers that Jim first put on the table, those are the numbers that exist now.
Yeah.
You see, when you write down 75% and all that, that is what I think the districts look like right now. Okay? Which is why I think that was the mistake. They took a table showing the existing demographics, which was the first table we displayed. And then this table here is the corrected table, and they caught their error. And then this table here is the table that was corrected, that is attached to their proposed map. Can you put the map up, Jim? How it looks? You don't have it, or?
Dude, just a minute, it's here somewhere, folks.
There it is. There's the map. So it's similar to our map. It's just where the populations, they don't follow the principle as much of minimizing municipal splits. What they're trying to do, I think, is back out the changes, you know, where the county, when they were drawing their district, was trying to draw the line to follow the population movement of African Americans.
Yeah.
I think their expert just reverses that and undoes that, right? And ends up with a map that looks like that. I think. I'm not, that may not be.
Now, when you say as of now, are you talking about today, or are you talking about 2021?
2021, the demographics of
Right.
2021.
So everything we talk about is based on 2021 demographics?
Correct.
Okay.
Well, yeah, the way the
It's on the census.
the population numbers are the census numbers.
Mhm.
You don't, there are estimates that are put out every year, but you don't, Jim, am I right? We're not relying on those estimates, right? This is all 2020 census data. Did I lose you, Jim?
So can I ask a question? So is there more African Americans in Jefferson County than white Americans?
No,
Okay.
there's not.
Okay.
The population of African Americans in the county is about 43%.
Okay.
Is that right? I think that's right.
That's
It's
right.
it's in that, it's in that range.
Yeah, it's 42, 43.
If you add minorities and add Hispanics into that, the minority population is about 48%
Okay.
of the county. So it's,
Is
yeah,
that now, or you still
that's
refer
the
back
2020,
to?
that's the 2020
All
census
right,
data.
okay.
It may be different now. You're right,
Yeah.
Congressman. It may be different.
And I just want to say this, that that's probably an error. And I say this everywhere I go, regardless of.
But they relying on 2021 census.
Okay, but this
Okay,
is what I'm saying,
2020
Congressman, because
Yeah.
we do not do census. That's why we got all these black elected officials. Because
Countywide
we don't
judge.
do census
Yeah.
as a culture.
Yeah, no, that, you're right. I mean, that, now, what I'll say is that the folks who do the census, well, I cannot say that for the people who are in power now, okay? So I'll hedge
Yeah.
that, right? But I'll say that for prior administrations, the folks who are running the census, they understand that there are response rates differ from community to community.
Yeah.
And they try their best to estimate. They try to do things to figure out what that under response rate is, and then try to make projections or corrections to their data that reflects this problem. I'm not sure this group's going to do it, the folks that are in power now, right? I mean,
Yeah.
but it still does represent an undercount. I don't disagree with you that in certain populations, like I'm Hispanic, right? So I know a lot of folks. I grew up in Miami. I know a lot of folks in the Hispanic community that just don't respond.
Right.
Somebody knocks on your door, you go hide, right? I mean, I hate to say that, but that's the reality of it. And that's even worse now, right? So.
Nobody's knocking on the door anymore. That's when I was a little boy. You do it online, and we don't do it.
Well, you're absolutely right, and that's a problem. And for a lot of communities, minority communities, we have to figure out how we're going to solve that problem.
Right.
Otherwise, there's going to be continuing to be an undercount.
Well, let me take it a step further though then. What about the percentage of registered voters? Are there more white registered voters in Jefferson County than black registered voters?
No, I think they're about equal. Is that right, Jim? Jim knows. He's the.
I think you may be, are you muted, Jim?
Hey, Jim?
No, I'm not muted.
All right, good, okay, I can hear you now, go ahead.
I just can only hear half the conversation. I can hear
Do you, what is the percentage of registered black voters relative to white voters in the county?
I don't have that figure at hand, but in general, I think it's a higher black registration rate, but I don't know for sure. I mean, I don't have that number.
Yeah, so it's not, I don't think there's a significant difference between registered. Now, being registered, that's only part of the,
We understand that. We
right?
Turnout.
Exactly, that's a whole different issue.
That's why we need that lawsuit against.
Yeah, no, you're right about that. If I can figure out a theory, we'll bring that. I know I'll have a plaintiff if I bring out that theory. So, all right, well, is there anything you want to say else, Jim?
Well, that's it. So we have to wait and see what happens.
Right,
That goes forward and what happens in the.
right, and yeah, that is a good point. And Judge Clement can probably fill you in on what can we expect from these, we've taken a very important hill in this battle. But I'm not sure, we're facing, a more challenging appellate court. Now, I'll say this, they have not granted a stay yet, right? Typically, we actually got a briefing schedule that was entered yesterday. So the county's brief is due November 10th, is when their brief, there are two issues. There's the stay issue is where the county has said, because when the judge entered her conclusions of fact, or her findings of fact and conclusions of law, she said the map that exists now is unconstitutional. We're not going to use that map again, okay? As far as she's concerned. That map's got to change. The county was given an opportunity to propose a change. They said, oh, we're too close, we're a year out, we can't do it. Right, okay. And then the judge said, all right, well, voters, you propose your plans. You've seen the two proposals. I think I would be happy with either one.
Right.
To be honest. Those are good, even though Jim gave me a little heart attack there with the first table. But so either map, I think, would be fine. So she's gonna look at that. They have until Wednesday to file their objections, the county does, to the maps that we have proposed to Judge Heikler. So LDF and our plaintiffs here, the voters, we've each said, Judge, we would like you to do, we've said, we'd like you to implement this map. LDF says, we'd like you to implement another map. They're both fine maps, okay? They both correct the violations. They do what the judge said needed to be done, and that is propose maps that don't violate the Constitution. And that's what we've each done, and you've seen the results. She will now, if there's not a stay in place by the 11th Circuit, if the 11th Circuit says, if the 11th Circuit hasn't entered a state, she will then order a new map. And that map will govern the 2026 election. Even as the appeal works its way through. That's why they moved for a stay. Because the litigation, the appeal, will not get resolved until sometime next year at the earliest. But by that time, it's too late to put in a new map, right? In the summer of 2026 is too, well, yes, our position is it would be too late in the summer of 2026 to put in a new map. So if they don't grant a stay now, or if they don't grant a stay in this case, then one of these two maps is likely to be the map that gets put into place at least for the 2026 election. And then the 11th Circuit will consider the case, and they may agree with Judge, they may not, with Judge Heikler, they may disagree with her. There are arguments, you know. There's one thing lawyers know how to do, and that's argue. So there's going to be a lot of arguments back and forth. And the 11th Circuit's going to have to decide who's right, whether the judge committed an error in her findings and her conclusions. But if they don't enter a stay now, that ain't going to happen until at least 6, 7, 8 months down the road, at least based on my experience. I don't know, Judge, would you agree with that?
I agree.
Yeah. So
So you saying now, so what kind of time frame is that when you say now? If they don't know a stay?
I think if they do not enter a stay, what would you say, Jim, by it's unusual for them to have what's called merit briefing, briefing the merits, right? Right now, we're just briefing the stay, the motion for a stay, the request for a stay. We've briefed that. That's been done. The 11th Circuit has had it in front of them now for at least, I want to say, they've had it for a week, right? Because I think that's when all the briefing, because the briefing was, it was really expedited, right? We had to file our brief opposing the judge, let me back up. They first filed a motion for a stay with Judge Heikler. She promptly denied it, okay? Because why is she going to stay in order when she finds that there's a violation of the Constitution? She's not going to do that. But you got to take that step first. You got to ask the judge first. She denied it. They then immediately appealed. The 11th Circuit gave us until October 6th. So I have to take that back. We haven't finished the briefing yet on the stay. I was thinking of the district court. We filed our opposition to the stay in the 11th Circuit on October 6th. They have until October 14th to file a reply. So they have filed their motion. We have filed an opposition. They still haven't acted, right? They don't have to wait for the reply to enter a stay. The reply is due October 14th. And not the 13th, because that's Indigenous Peoples Day, right? Or we used to be called Columbus Day. So they have their reply, but what I thought was interesting was that they entered, and it may or may not mean much, but they entered a briefing schedule on the merits Friday evening, right? So they enter a briefing schedule on the merits Friday evening without having ruled on the stay. So if we get to the point where we're doing merits briefing, in other words, briefing whether the judge was right or not, my feeling is there ain't gonna be a stay. But I can't, you know, if I had a crystal ball, I'd be as rich as Elon Musk.
We have a copy of the remedy plan 1 that you passed out.
Yes, ma'am?
And I think I heard you say you have a copy of the remedy plan 2.
No, there's only one, we only proposed remedy plan, one plan, what's called the out-of-condi plaintiffs. LDF, they proposed a separate plan. Unfortunately, I don't have copies of that plan.
Okay.
You want to add anything? I've done all the talking.
Well, you've done all the talking because you've done virtually all the work.
No, Jim's done.
We are very, very blessed to have two of the best voting rights lawyers in the country representing the black community. And you know Jim Blacksher. And Jim Blacksher has done voting rights work for as long as I can remember. And he's about the best there is, I think, in this area. So we're very blessed. And we have a very good judge, Judge Madeline Heikkila. And she calls them as she sees them, and she tends to see them right. Richard and I have been sort of on the sidelines, but
Judge, I hate to interrupt you. I'm not in the habit of interrupting a federal judge. But I'll have to say, without the support of the community, this is, you know, we've all been lawyers. We've all been at the trial. We all worked on this case together. Different, you know, you have different things that need to get done. I mean, there are a lot of moving parts. And I can tell you, without the judges and Richard's assistance and participation, this case doesn't get done. Okay. It just doesn't. So I appreciate the kind words, but this is truly, because what are we doing? We're representing voters, right? We're representing our community. We're trying to change things. That can't be done by just one or two people, right? So.
And I want you to be not deceived. All 5 of the commissioners are now represented by the same law firm that represents Donald Trump. All 5 of them. And they have opposed us. All 5 of them. You should know that.
Wow. Oh, my goodness. What an update. I know, right? That's significant. It is. That's a guideline.
It's the Trump law firm.
That's right. Come on.
Well, fight on, brothers, I tell you, we behind you.
Yeah, unfortunately, this is we're in a big moment.
Yes.
Right.
And other states are as well.
There are a lot, exactly.
Texas.
There is an argument that will be had on October 15th. If you can go on the Supreme Court's website, if you have the time or inclination to do this, and on their website there's a live feed, and you can listen to the arguments. There's a case called Calais versus the state of Louisiana. That case may very well decide whether what we do here today has any future, right? Whether there are going to be any constraints on whether, because the thing, when you combine a bad Calais decision with the decision from last year called Alexander versus the state of South Carolina, when you combine those two, and I'm hopeful that the Calais case will not turn out as bad. Some people predict that it will just basically gut Section 2 of the voting rights. They've gutted Section 5. If they gut Section 2, they pretty much undermine, the
whole 65.
yeah, exactly, the people who suffered
A clawback.
to get the 1965 Voting Rights Act passed, all the suffering, pain, and loss
That's right.
that went to that fight, this court may undo. And that's, it just, it sets back the idea of having a democracy, right? But I'm keeping my hopes up high. I didn't think the Milligan case would turn out the way it did, and it turned out the way it did. That's the case that we had, that's the congressional redistricting case that Judge Richard also involved in. In that case, that's the one that created the second minority district, for congressional district number 2, where we have Shamari Figures as our representative. That's called the Milligan case, and I didn't think that case, I thought that case, it was a close call, we won 5-4, and I don't know, the question is what Judge Kavanaugh's gonna do. He's one of the justices that kind of, he likes to say, oh, I'm so concerned, but then votes in a way that just, your words are not matching your actions, right? So, I don't know. So I'm hopeful that the same Milligan 5 will come to their senses and say, we can't go, a charge that's unfortunately being led by Judge Thomas, by Judge Clarence Thomas and Judge Alito. It's hard to understand, but you're hopeful that the 5 that held up on the Milligan case will actually come to the same conclusion in Calais and keep the voting rights, law, section 2, as it was amended, keep it intact and not undo it. Because I don't know if they do that, I don't know where we're at.
Well, since ours is a constitutional claim,
Right.
then it may not be all bad for us.
Not on this case,
Yes.
for now,
Yeah.
right? Because the problem is this, on the constitutional claims, Judge, you're right. The problem is Alexander. And that's sort of the way Alexander handles equal protection claims is it's a challenge. We think we're okay, because we think the evidence we have satisfies what the court said in Alexander. More than enough. And the judge, in her opinion, exhaustively discussed Alexander and gets it right. Why that case? But that case in the hands of wrong judges will wreak havoc, I'm afraid.
You're right.
And that's just the reality.
Can I jump in here for a second?
Sure.
The audience needs to know that we, the Idaho County plaintiffs, submitted the plan that you see up on the screen now to the county commission as a proposed settlement over a year and a half ago. They never responded. And if the Court of Appeals denies the commission's motion for a stay and sets it for full briefing on the merits for long term, that's the time when there's no excuse for the commissioners not to settle this case and spend more taxpayer money. And that may be a role for you, the public, play more forcefully than ever.
Right.
It should not have gone on as long as it does. It's not a hard case to win, and it should not be a hard case to settle.
So if you like the plan that we've shown you, that we've submitted to the court as remedial plan 1, we've asked the county commission in discussions to settle this. As Jim was saying, we did that more than a year ago. Said this is what we would envision. We think it's a fair plan. It keeps municipalities together. That's important, right? And they actually were. Well, I shouldn't say they expressed an interest. They asked Jim, the county's lawyer asked Jim after the deposition of Tony Fairfax, where Tony Fairfax talked about remedial plan, an earlier version of remedial plan 1, right, in his testimony. He asked for a copy of it. So, and then we engaged, we sent it to them and said we would settle if you agree to this. What's the saying, crickets? That's all you could hear, are crickets. And so if I think, hopefully, what Jim is saying, if the 11th Circuit denies a stay, then the county has to do something, right? It can't use the map it adopted in 2021 anymore. It's got to have a new map, and it's given up the opportunity to present its map, right? So they're gonna be between a rock and a hard place.
And what that means is that we, the lawyers, cannot contact the commission,
Correct.
but you can. And so both black commissioners, you ought to be on like white on right, convincing them to go for our plan. You can do that. We can.
They don't
And you do that as a citizen, right?
Oh, yeah.
As a citizen. Yeah, you have a right as a citizen to petition your government.
But let me ask you this, Attorney Roku, so I need to understand that, so this settlement.
There is no settlement.
The settlement that I was saying.
We
I need to
proposed.
Proposed, I need to understand the time frame on it, because you guys are blowing me away.
Well, we proposed this back, Jim, was it back last summer? Hey, Jim, can you hear me?
Yeah, I have to go check my emails, but it was around the middle, yeah, close to summertime last year.
It was last year.
So I need to understand the timeline before they have before the cases been filed in the federal court.
Right, we have filed our case. The NAACP, LDF filed their case, and then we filed. Well, early on we moved for a preliminary injunction, right? And we're now talking 2024 is when we did this, or maybe 2023. Let's see, I'll tell you in a second. Yeah, it was 2023, okay? In 2023, when we filed the case, in the summer of 2023, we filed a motion for preliminary injunction, asking the judge to immediately enjoin any further use of the map. Because we're anticipating the next election is 2026. So we know how long sometimes these things take. The judge did not agree with us, precisely because the election, part of the reason is because why am I going to enter a preliminary injunction when the next election is in 2026, right? So, but we wanted to get all the evidence out there. We wanted to make sure that the judge understood our case, and a preliminary injunction hearing is a good way to do that. So as part of that process, the county's lawyers took what's called a deposition of our expert, Tony Fairfax. He takes, deposition is when you get in front of the lawyers and the court reporter, you swear yourself. Usually happens in the conference room, but he gave his deposition. And it's my understanding that after the deposition, some of the lawyers for the county were intrigued enough about what Tony Fairfax had testified to and the approach, that they asked that we email them the map, the Tony Fairfax, and the data behind it. And we did that, I want to say it was quite a while ago, and hadn't heard it. Because the case, remember, the case, well, was it 2020, we filed in 2023, had a preliminary injunction, then I guess we did a lot of discovery, and then there was motions for summary, there was a lot, I'm trying to close the gap between 2023 and 2025. There's a lot going on.
We had a trial earlier this year.
Yeah, that's what I'm saying, we had a trial earlier this year, we had the preliminary injunction in 2023, I'm pretty certain about that.
Yeah, we did.
And then we litigated, we have motions and just litigated the case.
Yeah.
Uh,
Now, I mentioned that we can't talk to the commissioners, but we can talk to the lawyers, and we talked to Theo Lawson, the county attorney. And he indicated to me, I guess it was 2 weeks ago, that they will be interested in talking once the circuit acts on the motion to stay. Yeah.
So, and that's the thing, if the stay motion a lot of times is a big deal, because what ends up happening is this. If they deny the stay, they have to have a map in place. Because the judge's order is still, the judge says, do this, right? Unless a higher court says, don't worry about that until we resolve it, you gotta do what the judge told you to do. And so if the stay is denied, then they have to have another map. And that's when they'll probably talk to us about another map. And then once that map goes into place, because it'd be better to resolve it rather than litigate it, once that map comes in and the 2026 election is run after that map, we're right up on 2030 and the census again. And they're gonna have to redo another map 4 years later. So it kind of doesn't make any sense to continue litigating. That's sort of the dynamic that's in play. That doesn't mean that they won't. I've seen crazier things. Nowadays, you see crazy things, you know? But yeah, I mean, that's, you know.
Let me point out one other thing, Richard. The Court of Appeals, they take some time. Thinking about other cases like in Jacksonville, when there was a preliminary injunction and motion to stay. But they can take a month to 2 months. They have to write a pretty careful opinion if they're going to grant or deny the stay that address the merits of the case and so forth. In the meantime, if Judge Heikkila goes ahead and issues her order adopting a court-ordered plan, that plan becomes the governing law. And there's no longer any need to settle at all. So, and there is some incentive for the county commission, if they want to settle, to do it before Judge Heikkila. This tells them exactly what plan they're going to use it for the settlements.
And Jim makes an important point. I mean, I don't know when and if the 11th Circuit's going to grant a stay. They could decide to do it in December, January, I just don't know, right? But my experience has been they usually do these sooner than later, right? Because they understand the dynamic of what happens, because there has to be a plan in place. And you can't run on, I don't think they just leave a plan that a judge has found to be unconstitutional. I mean, you gotta do something. You either stay it or you change the plans. Well, I'm an Alabama fan, so I know there's a game going on.
Let me just say this about the two black commissioners. If they had wanted to, either one of them could have asked the court to realign the parties so that they were with us rather than with the Trump group. But neither one of them did that.
Oh, my goodness.
Well, you got
Thank you for hosting this.
2 more minutes on that.
Who are you with?
I'm with Birmingham Watch.
Birmingham Watch, right. Do you have a question or anything?
I was gonna get with them later and maybe get a phone number. There's a lot of this stuff covered. I want to make sure I had somebody I could call up for double checking questions. But if y'all have any.
We good? All right.
All right.
Thank you.